about the people who have started the EEOC process a long time ago, or?
It's what it is technically we'll have the right to fully litigate those claims in court once EEOC issues a notice of it right to sue letter.
Okay, because 2 of them have appointments.
Yeah, and everybody who's filed that should go through it, and we can help along the way as well.
Okay. As far as OSHA ruling goes, do you think now that the Tennessee law that passed, that a company cannot ask you for a vaccine card, that everyone should try to go back to work and see what happens? And I would like to insert on that it says you can't ask for a vaccine card, but that's for access to the building as well. There's fine print there.
So we've added the Tennessee state law claim to the amended complaint. So so that is, I mean, it's obviously they watered down the law, but we have added that. But at this point, I think I don't think trying to go back to work would necessarily work, because I think we have to get judicial relief. Is my understanding, unless somebody's status has changed. My understanding is everybody's on, aside from one person, everybody's on unpaid leave of absence, correct?
Not Robbie.
Yeah, except Robbie.
Right.
Yeah, except Robbie.
Okay, the next question is a stay on certain cases, just wondering why certain and not all. We are all in the same boat.
What do you mean?
Well, are you talking about national? I'm not sure who wrote that question, but are you talking about on the national, there's certain stays? Anybody? I don't know, but I guess we'll move on from that.
Wasn't there a stay in the Fifth Circuit?
What the Fifth Circuit granted was a stay as to the OSHA mandate, but Tyson was not depending on that for its actions.
What about the federal contractor mandate?
The federal contractor mandate doesn't yet have a stay, but there are cases pending with that. But also, they didn't claim that was their basis either. Tyson claimed just general federal officer status on grounds of the emergency order to keep food supply going. That is their predicate. They may add some other components, but they weren't relying on either federal contractor or OSHA for that.
The condition of employment was not as such when they signed on and hired in some over 20 years ago. How does that work when they are now saying it is a condition of employment?
Say that one more time.
So when they were hired in, getting the vaccine was not a condition of employment, and then all of a sudden they turned it on and said this is a condition of employment. How does that work?
That it doesn't impact our claim because they're not arguing a contractual authority. They're arguing that their position as a federal officer to keep the food supply going required them to do this. Our argument is that that's not the case, and that even if so, that did not provide for discriminating on a religious basis.
Let's see. Unemployment. Will I get unemployment while on LOA?
You can request it, and I think you should get it, but that'll be up to the Tennessee Unemployment Assistance.
And I have had conversations with legislators about it. They also feel like that you guys should get it, but it depends on what the law is. They said how it's interpreted with the exact language.
Yeah. I mean, my view is this is unemployment legally. So you just might have to go through an administrative appeals process to get it.
Is that the definition of unemployment? Is that a state definition?
Yes. And unemployment is, you're fired for cause, or fired not for cause in essence. And it's, everybody's unemployed. They don't have the job. So calling it leave of absence doesn't change that. I'm sure Tyson may think it does, but it should not legally.
What is better, termination or leave of absence?
Doesn't make a difference for our legal position.
Okay. Supplemental income. If I do PRN nursing, can Tyson end my leave and benefits?
I don't think so. I didn't see that as part of what they said. I mean, all they really said is we're just not going to call it a firing. Certain benefits may continue to apply, but I don't see how getting a different job should impact that.
And how would that impact unemployment?
Shouldn't impact unemployment either, in my view. Oh, you mean if they get another job?
Yeah, if they get another job to work, because apparently the conversation was, Carolyn, you might be able to speak to this. When you guys filed for unemployment, they said you were denied. Is that right? I want to put words in your mouth. Yeah, they were denied.
Yes, it was denied, and it was denied based on he did not have 3 places of employment that he searched out to, but Tyson told Chuck that he could not look for another job or have another job, but they also told other people at the plant that they could.
They can.
So,
they absolutely can look for another job.
Okay.
Okay. Let's see. Does this apply for everyone else who's seeking employment? Yes. I guess we just answered that. What would end someone's benefits?
You mean that it depends on the language Tyson used. In other words, I think Tyson's not going to take proactive action to terminate benefits outside of certain notices being given to Tyson.
And Robbie should have been offered COBRA at this point, right?
Yes.
Okay. And then also today we had, Jamie, you might be speaking to this about them paying for your training.
Yeah, so I discovered today that my certification as an instructor for CPR, AED, medic, and first aid instructor had lapsed. And I called my boss, and she sent me a recertification link, which they have to pay for when I get recertified, and they did that.
Okay.
And Carol and Chuck got a raise.
He also received his bonus for the year.
Oh, good.
That's
good.
great. Yeah,
Good.
that's good. So how do you get a raise during unemployment?
How do you get a raise and not get a paycheck?
Right.
Yeah, 0 times 0 is 0.
Yeah.
Additional questions. What grounds gives Tyson the right to force their employees out?
I mean, Tyson is claiming necessary to protect the health of the food supply. That's Tyson's excuse for everything now. Our argument is that it's not a legitimate excuse for discrimination on religious and disability grounds, or perceived disability grounds.
What about all that food we produced when there was no vaccine for 18?
Right. Yes. That's part of our argument.
Will we get our jobs back if they have hired someone for my position before the courts rule in our favor? Can I get my same job back?
That the court can issue, part of the remedies that can be awarded by a jury are back pay, and they can't technically require them to re-employ you at the same position. What they can do is give you the monetary value as if you had been.
Okay, so that was the next question. Will they have to give us the same or equal pay or promoted position pay?
They have to restore you to the position you would have been in had they done their job legally, if we prevail. So that includes damages for back pay, front pay, up to a certain degree, a certain length of time, and also potentially emotional damages that may have been accrued as well.
And they just had a recruitment event where they handed out free chicken, and they put a sticker on it that said both plants were hiring, and the rate has been raised now.
And the sign-on bonus. They also get an extra for having perfect attendance. And the thing yesterday at Newbern had a big banner that says, "We support our troops." At the same time, taking a big dump on their freedoms.
Jamie has perfect attendance, but he was let go. Or LOA'd.
Yeah, he's got the sweatshirt to prove it, or the vest.
Yeah, I got the vest to prove my perfect attendance. Next May, it would have been 5 years perfect attendance.
If we don't get our jobs back, will they have to offer a healthy severance package?
Well, the damages would be, they could settle to anything. But if we were to win, then damages would include all of what you would have been paid and would have been entitled to had they conformed to the law.
Do you think this will take a month, a year, or longer?
Longer than a year.
At what point do we make them famous for belittling our faith?
By winning the case.
Could we use the discrimination and bullying as leverage to get what we want? We have some really good documents and recordings. Well, I think that's part of it.
Well, I mean, the goal is to prevail or motivate them to settle, which, we'll see whether they will do.
Just trying to understand why we aren't going at them with both barrels. Okay, court ruled Tyson is a federal agent, which you've kind of covered that. Does this mean they are limited by Constitution and First, Second, Fourth, Fifth Amendment all apply, plus bound by Religious Freedom Restoration Act?
Yeah, that's the amended suit added all of those claims. They're going to fight that tooth and nail, but we did add all of those claims on that exact basis.
Okay. And that is all the questions that were written to me. I've been trying to comb through this Tennessee law as much as possible, trying to understand information. But I do have one question. Do you know about what type of account that we can have? Can we use a C3 if people want to donate funds so that we can get it to these people? I already have people asking. We are a C3 through our coalition. I'm happy to use that. But I've also been told that that probably wouldn't go through the C3. What can we do to do that?
That I'll have to take a look at.
Okay, so the whole thing is people want to donate for tax purposes so that we can get these guys taken care of and they don't have to worry about paying their bills.
Who was it that told you that your C3 would not work for that purpose?
Mark, we're part of Health Choice. I don't know if you've heard of that or not. But we are a national coalition, and then Tennessee is obviously a branch of it. But it's through Health Choice. And then my next question was going to be asking Mary Holland if, I don't know if CHD could help us with something since they're already in the fight anyway.
Was it something about the structure of did they think a C3 could not be used, or your particular C3 could not be used?
I'm guessing it's the particular. He didn't say that, but the way that we're structured is educational for, like, we have our C4 for legislative work and then C3 for educational materials dealing with vaccines.
Right.
So that, I don't know the specifics legally of that, but that's what I'm happy to get you information on it, but I have people waiting to donate at this point.
I got you.
But I can't get a straight answer.
And they want it to be a C3 or C4 for tax purposes? Or do they just want to, could it be a GoFundMe or anything else?
It could be anything really, but they obviously want a tax write-off. I mean, the people who are given $5-10, they don't care, but some of the larger donations, they would like to have a tax write-off. And I was just trying to, I don't care what the heck the account is. I know GoFundMe will probably silence us or take our account down. So I didn't go that route. I don't know what the competitors to GoFundMe, I don't know what they are. But I don't care what it is. The people who want to donate more, solid donations, I guess they would like to have a tax write-off if possible. So I'm just trying to make it happen.
I got you. I'll take a look at that.
Okay. Do you need me to send you anything, or are you just going to figure out how we can on mine?
That information was enough. I'll
Okay.
take a look at whether that definitely restricts it. It might. So it might have to be a separate organization.
And we're not trying to reinvent the wheel. If we have partnerships with these people who might be willing to do it, let's try that first. And if not, then I'll just start collecting, and people can donate if they want, not if they don't want to.
Right.
But okay, that's all that I have on my end. Anybody else?
I'm just wondering, what do I do if Tyson calls me next Monday and tells me to come back to work?
I mean, I would say yes if that's what you want, and they're no longer wanting to do that's up to each individual choice. But that would effectively, if they did that, it moots most of the legal claim against them, because then it substantially limits the amount of damages that could be claimed against them. So if they were to do something like that, then it's up to the individual, but basically that would mostly end the lawsuit, regardless of whether you took it or not, as to that individual.
Because I'll be honest with you, I'm kind of expecting that. I'm kind of expecting that they intend to relax the situation, and I think they're going to offer testing. But here's the kicker: I'm going to have to go back to a job where this booster is about to be mandated, and part of my job responsibility will be injecting people with something that they're taking under duress, and I will have no legal protection to not do that if this suit drops.
Well, I mean, I assume the suit will be able to move forward at some level. The other thing is, if the booster gets mandated, that gives us injunctive relief again, because there'll be emergency injunctive relief. Because right now what it is the courts are determining that unless someone's saying I'm about to take the shot, then there's no injunctive relief available that you can, or not the kind of injunctive relief that preliminary emergency injunctive relief. We're still asking for permanent injunctive relief, which is part of our grounds for being able to go to court without waiting on the EEOC. Now, the Sixth Circuit has said, they've been one of the few circuits to say you still have to go through the EEOC even if you're asking for injunctive relief. So I'm wanting to preserve that, to challenge that, because that should get reversed at some point. But we're not out of the gate. But once there's another round, if Tyson comes back and says now you have to get the booster, then whoever it is that doesn't want it, we get to ask for emergency relief. Also, I'm hopeful at that, depending on the time frame of that, Tyson will now start to argue they're not really a federal officer because of the suits, the amended complaint. And we'll see if they really want to stick with that. They just wanted to dodge the bullet out of the gate. But that may get reversed. Also, Public Citizen wants to look at filing an amicus. If we file an interlocutory appeal on the federal officer jurisdictional issue, they want to challenge that. They don't believe Tyson Foods is a federal officer for these purposes.
I don't either.
Yeah, no, I agree. And I think that the court's going to be put in a position where they're going to have to either pretend they're really not a federal officer. How are they a federal officer for removal but not a federal officer for liability? And so we'll see what, and I don't know how well Tyson thought that through in terms of the risk they created by adding that component. But yeah, that's the booster will be another round of emergency injunctive relief, and I'm hopeful we get clarity on whether they're a federal officer before that time frame comes around. So that, because if either they're a federal officer, in which they should have added liability, or they're not a federal officer, in which case we can then go to a state court to get relief. And clearly they're paranoid about any action being brought in state court, or they wouldn't be resorting to these, this extreme remedy of federal officer claims and federal preemption claims. And so I think that, but that will be a bridge we can cross then, but we'll be in a better, more informed position legally if and when that ever comes about.
So if they call me, say Monday, they call all of us and tell us that we can come back because they've got a testing thing set up, we pretty much have to go back.
Yeah, mostly mooted your suit at that point. When we can keep going forward with the suit, but there's basically almost no damages left, because they will have reversed their position in a timely enough manner to limit their exposure.
How do they do that with the assumption if they say, okay, you can come back, but you have to test, and the vaccinated don't have to? They're assuming that the vaccinated are not carrying it or able to spread it when we know that that's not true.
I agree with that. It's still an illogical policy to have, but it's one that gets them out of the immediate legal trouble of this case.
And there are a lot of people doing that. All the colleges, all the people that work for the school systems, they're all doing that.
Yeah, for the most part, once the OSHA mandate failed, a lot of people that were on the fence started moving the other way. The people that are staying hardcore are the ones in liberal jurisdictions. So, they denied, but a couple of judges in California denied injunctions from Kaiser, denied injunctions against the school districts, denied injunctions for firemen and cops. In Maine and New York, denied injunctions for nurses. They're choosing to litigate in those courts because that's a lot better than litigating in other circuits. Now, in the United case, they also denied the injunction, but they said that's because monetary relief provides recovery. So the only grounds we had for an injunction was, I'm about to take the shot unless you enjoin it. If that's where, in terms of emergency injunctive relief, we can go back for emergency injunctive relief if booster shots come back into play. I talked to an executive for Purdue